good morning for those in Latin America. Good afternoon for those in Europe. It's a pleasure to have you on board with us for this presentation. I think the advantage of having like an invitation-only webinar is that we know most of the people there, so we don't need to do rude presentations. For those who maybe don't know me, and Enyo, we are one of the leading disputes firms in Europe. We do disputes only, and we have been one of the first firms in Europe to establish an ESG litigation practice, and we have been working with companies now for almost 6 years at the very beginning of the ESG trend in Europe, both preventing their cases and helping them prevent cases, but also representing them in a series of class actions. And the idea today, some of you have attended our webinar maybe 1 or 2 years ago, where we were really focused on the idea of ESG as a whole, as a general concept. And now the idea is much more to focus on something which is very concrete, which is the due diligence obligation of companies. And I think for that, we are very lucky to have Wallbrook with us today. And for those who don't know Wallbrook is a global ESG and human rights consultancy that supports companies in different sectors: chemicals, consumers goods, agriculture, not coal, tobacco, and arms, but a number of extractivist important sectors. And they work on a very interesting manner, and that's why I thought it was really nice to have them with us. They are a consultancy that work kind of a bridge between the advocacy community, us, and business, leverage international best practice in business and human rights, cultural and linguistic expertise to help investors and companies implement United Nations general principles. And I think the idea is Camille and Mariana are the guys who are the specialists in doing the due diligence. I and Enyo, we are the guys which will probably intervene together with them if things go wrong, or especially if we can prevent any kind of ESG litigation under our more corporate governance, or under the angle of supply chain rules. So I thought it was really nice to have like those two angles today. So the angle of the ESG litigation and the angle of the due diligence. Just to quickly present, so Camila and Mariana. Mariana, she's a partner and head of ESG and human rights at Wallbrook. She's a human rights lawyer, which is really refreshing, so you don't need to, hear me talking all the time about disputes. She has led human rights due diligence and impact assessment for Brazilian and global clients across Latin America. So we will explore a lot of their experience in Brazil, in Latin America, with some very concrete examples. But also Asia, Sub-Saharan Africa, and Middle East. She previously worked on human rights at the United Nations, Amnesty International, and Global Witness. Camila is an associate at Wallbrook ESG Human Rights Practice. She specializes in human rights due diligence, impact assessment, and investigation with a focus on LATAM. Camila works on projects in high-risk environmental areas like the Amazon, collaborating with communities, NGO, and stakeholders. There is the agenda for us today. We have like approximately 1 hour. The idea for this webinar is that we really want it to be very interactive. So we really want you guys, everyone that's here was invited because they have, any kind of interest. They are working with ESG, or they have an interest in ESG, or they are studying ESG, or they are in-houses in companies which are already doing some kind of due diligence, or which are already working on those issues. So please share your experience. Please send us questions. There is a Q&A button. Just send your question, and we're gonna try and answer all those questions as we go, and probably try to answer as much as we can. I think the more you share the experience, the more it's going to be productive. I think the agenda for today, is basically for Wallbrook to talk us through a little bit about what are the main UN guiding principles on business and human rights. What are the rules that companies are expected to follow now in 2023, so that they can avoid liability for violation of due diligence, of human rights due diligence obligations. Human rights has been for a very long time this ether of, very transcendental studies, and now it's completely concrete. You as a company need to follow due diligence, human rights due diligence. You need not only to conduct those due diligence on your supplier, on your buyer, on your subsidiary, on your holding, on all companies of your group, but you need to prove it, and you need to produce evidence. And that is the tricky part of it, okay? So they are gonna go a little bit through a practical guide of how to implement human rights due diligence. Then I will jump into give you a little bit of the legal stuff. What is out there in terms of regulations? What is today the concrete rules that you as a company doing business in Europe, and mark my words, is not only being established in Europe, just doing business in Europe, you fall into the scope of the European regulations, and you need to conduct due diligence with people with whom you are working. So we're going to talk a little bit about the landscape. What are the rules out there? What you need to follow? And I will also, of course, go through all the litigation, all the cases today. There are already maybe 20, 25, 30 cases already against different kinds of companies in different sectors for all kinds of different arguments against, parent company for damage caused by subsidiaries because they didn't do due diligence on the subsidiary, because they didn't do due diligence on the company they are investing, or because they didn't conduct a due diligence on the company they are funding, et cetera, et cetera. So we're going to go through some of those cases. And then I will give the floor back to Wallbrook, and Marina and Camila will explain a little bit. We will present a very interesting case study. I think that's really one of the highlights. How can you really concretely work human rights due diligence in your company to avoid those claims? And then we're gonna do some crystal balling. We're gonna do, let's try to see what the future holds for us. Let's try to, understand what the case law, what the case is today, what the work of Wallbrook means in terms of what should we expect. And, as a spoiler, you should expect, unfortunately, but fortunately too, because it also, in a certain way, will also help the, the ESG, the environment. We should hope for a lot of regulations, a lot of cases, and a lot of claims. I think it's a non-return. We've come to a point today where there is gonna be a lot to discuss. So without further ado, I think we can jump into the next slide. And now we'll pass the floor to Mariana, who can, then continue this presentation.
Thank you, Danielle, and hi, everyone. It's a pleasure to be here with you. Thank you for taking the time for joining us. And we thought we would kick off this conversation with surprise, the UN Guiding Principles. And I see many of our clients have joined us here, so this is not going to be news to you. We always have so many conversations about the UN Guiding Principles. But I think there is no other way we could start a webinar on human rights due diligence, if not talking about the UNGPs, which is the acronym used by the practitioners on business and human rights. And basically, what are the UNGPs? And the idea of this webinar is really to be very concrete and bring you concrete case studies. So we'll be very quick in terms of the theory. But the reason why we thought it would be important to give you a quick overview of what are the UNGPs is because when we see all the EU legislation and other domestic laws being enacted all over the world, you know, they have all been based and building on the UN guiding principles. And what are they? Basically, they are a set of principles. They're voluntary. They have been in place since 2011, so it's not a new conversation. It's been 12 years that they have been around. And even though they're voluntary, there is an increasingly number of companies and investors that have been committing to them. And as you know, once you commit to it, then there are many responsibilities that arise from it, and also associated legal risks once you have made a formal commitment to implement them. And in a nutshell, you know, the UN guiding principles establish 4 key areas that companies and investors need to implement to be able to respect human rights. First one is about formally committing to respect human rights. And in other words, you know, what does that mean? There are various ways you can commit, and there is being a principle, it's not prescriptive in how that can manifest. So it could be a human rights policy on your website, it can be a public statement, it can be a formal commitment to respect human rights as part of a broader ESG policy. There are various ways that can manifest, but the headline is that you have to put somewhere publicly, you know, that you are formally committing to it. But, you know, that's not enough. You need to go beyond and then formally implement what your policy outlines. And that's what takes us to number 2, which means conducting human rights due diligence. And that's often the point where we get most questions from clients, because everyone understands and they read the principles and they understand it's clear they have to conduct human rights due diligence, but it's a very abstract term. And clients come to us often, you know, asking what does it mean to conduct human rights due diligence? And that's what we're hoping. We're bringing a case study later to you, and we'll take you on a step-by-step on, you know, how we conducted human rights due diligence for one specific case. The third one is about establishing grievance mechanisms. And for once, you know, that's one point where the UN guiding principles are very prescriptive on how a good grievance mechanism looks like and can be established in a way that is considered to be respectful of human rights. So a lot of clients come to us, for example, and they say, oh, we have a hotline, you know, we already have a grievance mechanisms. And, you know, we often say, let's do a review according to the criteria, because the concept behind the grievance mechanisms is much broader in terms of being available and being a trusted mechanism by stakeholders, being independent, and often a standalone hotline doesn't tick that box. And the last point is about, you know, a very common buzzword when people talk about the UN guiding principles, which is about preventing, mitigating, or remediating adverse human rights impacts with which you are involved. And that means, you know, once you conduct your human rights due diligence, you are learning and identifying the risks and impacts. But it's not enough to just identify them, then you need to act on it. That's what they are in a nutshell. Getting more into the specificities and bringing some concrete examples for you. We try to come up with a very clear workflow on how good human rights risk management policies and processes would look like. And you can see, you know, on the upper rectangle, it's about having that policy commitment. And we highlight in orange, which is, you know, one of the key things about, you know, good human rights practices and everything that the UN guiding principles are based on, which is another buzzword that everyone should be familiar with when it comes to business and human rights, which is stakeholder engagement. And that means companies shouldn't have top-down approaches. It's about talking to your internal stakeholders. That means your workers, your employees, but also any other stakeholder that might be at risk or impacted by your operations. And who are these stakeholders will vary from company to company, depending on their type of operations, the country, the sector they work on. But it could be local communities impacted by your operations. It could be consumers. It could be your clients. It could be wider society when we're talking about the risk of pollution, for example. So it's a very comprehensive scope that takes into account any potential risks to the people that might be your company might be causing or contributing or being directly to. And the workflow I'll pass very quickly. I don't want to get too technical, but that first step is about what we were talking about, identifying and assessing your risks and impacts, then followed by integrating and acting on your findings, fully implementing your due diligence, and then followed by tracking and monitoring your response. And the last point, which is, communicate, which I think is one that in our experience has been cause of tensions internally between human rights teams and then the legal functions within clients that are often, the legal compliance teams are often very mindful of disclosing information, disclosing what a company's human rights risks because of the risk of litigation, risks of to reputation. But the business and human rights agenda is very much about disclosing and communicating. But we need to recognize that there are tensions that arise from it. I'll hand over back to Daniel now to run you through the regulatory landscape.
Yeah, so I think, the best way to jump into regulatory regulations is to understand why we need the work of Wallbrook and why we need due diligence. It's not because, of course, we want to improve our business and we want to make it, more human in a certain way in terms of respect of human rights, but because there is today, concrete regulation. There is, say each country has a different regulation. Each country has its internal rules. But here I kind of, I picked two very important European regulations. Then I mentioned a couple of internal, internal countries regulation, and then quickly just to mention Brazil also has just started, the legislation process to pass on potentially, a couple of years, its own human rights due diligence law, which is the project.
I think we will move on and we can come back to the ESG regulation part later on. So here's the case study we mentioned earlier that we plan to bring for you. It was a human rights due diligence we did for a global company in their operations in Brazil. The phase one is what we normally call, and the idea here, before we start about the case study, is that there is not one recipe or one single way of conducting human rights due diligence. The case that we brought here is what we thought would be the most useful for you, which is a very in-depth kind of human rights due diligence for the type of operations that a global company would consider to be their highest risk assets. Because we thought, that's as far and as deep that you would normally go, and it's always easier to then, go less deep. But in some cases, if you're looking at low risk asset, there is a tight time frame and there is a small budget, for example, a credible human rights due diligence might look like a simple desktop research. So that's kind of the headline I wanted to get out of the way from the beginning. There is no one way of doing it. And that's an example of an in-depth one. So how we normally do it, the phase one is what we call an initial assessment. And the objective of this phase is to identify the most vulnerable rights holders and the salient human rights risks. Again, we have a few buzzwords here. Rights holders is the term normally used for people that might be affected by a company's operations. And as we said before, workers, contractors, communities, consumers, that will vary. And the salient human rights risks, and what does it mean, saliency, is about prioritizing what are the human rights risks that are more relevant for that company, taking into account the type of operations they have and the country they operate. And the importance of salient human rights risks is about, really getting to the core of where your highest risks are. Is the opposite of corporate social responsibility, where you have, traditionally you have a mining company, for example, operating, but then they build a school. So there is no offset of human rights, the same way you have carbon offset, that you might have one activity causing environmental impact, but then you can, buy carbon credits elsewhere, and you have that offset, that trade-off. That does not exist for human rights. So if a company wants to build a school as part of their corporate social responsibility efforts, that's great, but that does not mean that they don't need to assess and mitigate the human rights risks related to their core operations. So that's what we're aiming to do at the phase one. And how we do it, in this particular case, we reviewed more than 60 internal documents, and company disclosures. We send our clients a long list of documents. We have an NDA signed to give everyone the comfort that everything is confidential. But the idea for us is really to immerse ourselves on that company and understand, all the potential risks and how are they currently managing or not managing them. Then we complement the document review with desktop research, and what we call public record research, means looking at any press articles, NGO articles, perhaps existing court records against that company, regulatory fines, anything that we can find in the public domain that might give us more insight and help us understand better what is the track record of that given company. And we top that up with sector analysis. And even though we are experts and we have the institutional knowledge, for every case, we also talk to experts that, might be very familiar and have, a long track record of studying that specific sector in that specific region where the company operates. And they will give us further insights, for example, on how that company is impacting a certain indigenous community, or how a certain river might have been polluted as a result of that company's operations. And the idea is to be very comprehensive and collect as much information as we can on phase one. And then we move to phase two, which, once we have gathered all the data kind of from the outside, we have to apply a risk-based approach in terms of who are the people that seem to be most at risk. And how we do that, for example, is not, again, a rule that we will do surveys each time, but in this case, we conducted a survey with companies' employees. They had operations across Brazil, and I see many Brazilians here as well. Brazil is the size of a continent, and if a company has operations spread all over the country, there is still a layer of that is needed for prioritization of the human rights due diligence. And how do you prioritize? Is that what the UN guiding principles say is you need to focus on your highest risks. So we send surveys to staff to understand, are there certain regions of Brazil that seem to be most at risk, or, thinking about vulnerable populations, and get their insights and their experience for working for this company. And that informs, our plans for site visits. That's a key part of our in-depth human rights due diligence. It's really being on the ground talking to people and engaging with them firsthand. There's so much that is missed if you're not there talking to people and just observing how they are impacted, how is the company operating, and conducting that visual assessment. But also when you are, there are limitations about remote interviews, being able to look people in the eye and build that trust really helps us get to the nitty-gritty of what kind of risk that person might be suffering or might be a victim of. So that's the stakeholder engagement phase, and that might include one-on-one interviews, but also group interviews with the people that we identified to be most at risk. In this case, it was women, contractors, and LGBTQIA+ workers, and also affected communities surrounding our clients' operations in São Paulo. So we interviewed community members, but also their leaders and NGOs that work very closely with the communities to really understand, what was their experience. I'll hand over to Camila now.
Cool. So then, thank you, Mariana. Then after phase 2, we have phase 3. So we're using the findings from phase 1 and 2. We use Wallbrook's methodology to conduct the risk assessment to identify then the severity, likelihood, and attribution in accordance with the UNGPs. So these factors determines the company's responsibility and ability to act. I will explain each of these factors with more detail. I know they're very technical. So after we identify the salient risks in the company's Brazilian operations, in that case, which mostly related to working conditions, discrimination, decent work, health, safety, security, and the environment, then we assess the severity of each risk based on a scale, which is how grave or serious the harm would be. It's called how widespread the harm would be. This is like how many people would be affected by the risk if it becomes an impact, and remediability, which is the ability to restore those affected to a situation at least the same as or equivalent to their situation before the impact by the company. After having this severity factor, this will all become more visual in the next slide when we show you our matrix. But after having a severity, we assess likelihood, which is how likely is the impact to exist or to occur in the company's operations. And this involves considering the company's own operating context and the ability of the company's various business relationships to effectively manage human rights risks. So this can also be related to country risks, sector risks, and everything. So using the severity and likelihood, we plotted our findings on our proprietary risk matrix based on their severity and likelihood as defined by the UNGPs. So we have severity, likelihood, and then we assess attribution, which is the role of the company in creating the impact, and also the leverage, which is the influence of the company that the company has to effect change in the practices that are causing the harm. So attribution is also a concept that is very much related to the UNGPs. The UNGPs have all the commenters that explain what attribution is. So under attribution, for this case, we assessed whether the company caused, contributed to, or was directly linked to the harm. So the company caused the harm when its actions are alone sufficient to create an adverse risk or impacts on human rights. The company can contribute to the harm when its actions or omissions are insufficient to cause the impact, but the company's operations increase the risk of the impact or worsen the result of it. And then the company is directly linked to the harm when it has not caused or contributed to it, but it is associated with the harm through their business, to the company's business relationships. And then finally, current management reflects the mechanisms and the policies that the business has in place to identify and mitigate a given human rights impact. And to assess these, we have to review the company's policies, the practices that the company had in place to identify and mitigate the risks that we had initially identified. Then, as I told you, to become more clear, this is our illustrative risk assessment. So we draft this table and then for each risk, we have these, we break down the risk, the impacted right, who was impacted, and then conducted this analysis that I've just explained about scale, scope, remediability, which is the severity, likelihood, and then finally leverage and attribution. So all of this information then fits into our recommendations, which correspond with the current management and leverage that our client had over each of these risks. So this table is something that we deliver to the client in addition to a written report explaining all these risks and all the recommendations that we give to prevent or mitigate these risks. So just to give an example, one of the risks that we identified related to the use of subcontracted labor on the client side. So in Brazil, it's very common to use terceiros, which are the subcontracted labor. And so to assess this risk, we had to review as documents, we had to review subcontractor contracts, grievances that were filed through the company's hotline, and also interviewed some of these workers. And then when we were doing these interviews, the workers told us that they didn't feel comfortable to raise health and safety concerns or take sick leave, for example, without fear of retaliation from their managers. So we found that this risk manifested most strongly on sites that did not have any permanent or at least consistent presence of the client's direct employees. So because the supplier operated on the client side and its contract with the client stipulated that the client could exercise greater oversight of health and safety conditions or monitoring, we found that our client had a high amount of leverage to mitigate the risks because, yeah, the client had a good influence on these to mitigate the risks on the situation. So our recommendations in this case included ensuring a direct employee or a manager was regularly based at the site. So this would increase awareness and accessibility of the client's grievance mechanism, and the subcontractors would feel more comfortable with sharing their grievances and also ask for sick leave, for example, and also any health and safety concerns. Then finally, we go to phase 4, which is the phase of prioritize and act. So under UNGP number 19, the companies must first discern if and how its operations have contributed to or may contribute to human rights impact, which is, yeah, the phase that we just explained, like identify. And then the companies also have to respond based on how it is connected to this impact. And then the ways that the company can respond can be either by ceasing the action that is causing harm, or preventing the impact, or mitigating or the risk, or remedying the impact. So for this, we developed actionable recommendations to improve the management of the risks that we identified in the previous phase. For this, we also use the framework provided by the UNGPs. And then this also leads us to the prioritization phase, which is prioritizing the risks and recommendations based on, again, the factors that I explained in the previous slides. So we presented our findings and recommendations to the senior level of the Brazil operations and also to the company's global level. And we not only did the recommendations, but then the company came to us and said, okay, how are we going to implement these recommendations? Because it looks beautiful in the paper, but it has to be applicable to the practice and to the various teams within the company. So that's why we made a plan of action and support all the different internal teams, so compliance, legal, operations, to develop concrete objectives and a plan of action to implement the recommendations. So this is pretty much step by step of a human rights due diligence. It's an example. We try to be as clear and as practical as possible. But again, this is very much tailored to the company, to the sector, and it depends on various factors that are really particular to the company, to the client itself. So now I think I'd be happy to go back before we go to questions. I think I would be happy to go back to where Daniel stopped. It's fine, it doesn't change anything really. So Daniel, we are happy to have you back.
Thank you very much. Can you hear me now? Yes, sorry, my laptop went into complete meltdown. Probably didn't do my due diligence on my laptop. I don't know what happened, so I'm on my phone. But yeah, so just to quickly go through the regulation, as I was saying, I think there is two main European regulations that we need to be aware today. First one, which is the EU corporate sustainability due diligence, so CSDD, which is I would say like it's the most advanced one. It's gonna be probably come into force in Europe in 2024, and it's gonna be and then in Chile it's gonna be mandatory for countries in the EU. Basically, the interesting fact about the CSDG is that it basically holds liable companies who have failed to conduct due diligence of their throughout their value chain. And the word value chain is very important. It doesn't mean only supply chain, but it's broader, it's wider than the supply chain. It means any business, any company that has in any way contributed to create value to the product or service that is being sold in Europe. And you're going to tell me, well, but Daniel, there's a lot of uncertainty. So every company that has in some sort during the process of making a good or service contributed to the aggregated value of that product will be in the value chain. And the answer is yes. And it's scary. It's scary because, well, first, it's very broad, and second, there is still no case law. So what we see with the CSDG is that it will take some time, of course, for companies to incorporate it. It will take some time for courts to tell us what it means, really, and what is the scope, what's the limit to it. Is it like, the buy of the buyer of the buyer, or is it just like the first or second downstream clients or whatever? The thing is, which is very clear, is that if a company in Europe or a company that has activities in Europe does not conduct due diligence when acquiring goods or service from a supplier in Latin America or a supplier in Africa or in Asia, and that supplier violates human rights, then the company in Europe will be held liable. And what is very interesting is that the directive does not only apply to companies seated in Europe, but it has explicit provision that even companies who have business in Europe. So if part of your revenue, so let's say you are a Brazilian country or you are a Mexican country, and part of your revenue comes from the European market, you can be held liable for violations of human rights due diligence throughout your value chain. The second directive is quite a new directive. It's for the time being, it's a regulation, so it's still in the process of becoming a directive. It's deforestation regulation, and this one, guys, is explicitly aimed at Brazil and the Amazon. And it basically provides that we want in Europe deforestation-free products. And that's not my expression, that's the regulations expression. And that also extends the liability not only to the seller in Europe of a product that was made through, a subsidiary or through a buyer that was established in a deforested area or used any kind of, subcontractor that did deforestation in Brazil, but it will also hold liable the entire supply chain. So if, a company, let's say in Europe, is using someone in Brazil that, did not do or did not conduct a due diligence in relation to the deforestation or the degrees of expropriatory activities in Brazil, they can be held liable. And then, just to go quickly, all those regulations have been inspiring countries in Europe to have their own rules, their own set of laws. So in the UK, for example, we have the Modern Slavery Act, which is from 2015. So it's quite, it's earlier than the regulations. And for example, the Slavery Act is, of course, limited to only forced labor. And that's a very important criticism that we have here in the UK, which is the UK probably in Europe is the one behind, because honestly, the only liability a company in the UK will have in terms of supply chain is established only for cases where the supplier in another country is using forced labor, okay? And finally, we have already a very embryonic project of law in Brazil, which will, which aims to be Brazilian human rights due diligence law, which is PL 572/2022. So for the guys, I invite you to have a look at it. It's quite complete. It's like it's almost like a code. There's like 35 pages of rules and different provisions. But basically, it follows the European provisions, whereas we will be liable not only for our own violations of human rights, but also if we failed to conduct due diligence in any subcontractors that we use throughout the value chain in Brazil. So that's also very interesting to see some countries in Latin America also, developing their own regimes. And I think now we can go to the litigation slide. So I think the idea here is just to present a little bit of what's going on. So, I think, Marianne and Camila, they have presented a little bit of the due diligence, a little bit of the process. And what I'd like to really present you here is what's already out there. What are the cases already pending, okay? And I think we can classify those cases into three categories. And we can classify the cases in relation to the claimants, in relation to the object, and in relation to who are the defendant. For the first category, claimants, I think we have two kinds of cases. We have cases which are collective, proper collective claims. So claims which are brought in Europe by victims. So those are claims which have as claimants literally thousands of people on an individual basis. In the UK, they are managed together. We have GLOs, group litigation orders. So it's basically a judge that says, well, I want to manage those claims together for different reasons, but they are procedurally individual claims. I would say in the UK, most of the claims are those types of claims, mass claims. And then we have individual claims brought by NGOs. So let's say, for example, Client Earth or WWF or, Amnesty International, though those guys can bring a claim for different reasons. These, I would say in England, they are still a minority of claims. There is one claim now, which is very, it's on the news like almost weekly in the UK, which is a claim brought by Client Earth against Shell. which is a replica of the claim which was also bought in the Netherlands. I would say the place where those NGO claims have flourished the most is France and the Netherlands. Okay, the UK is still a little bit hesitant to give those NGOs absolute legitimacy to be an active claimant, and I will quickly talk through why in a minute. Then we can, I think, classify those claims in relation to the object. We have ESG. So we have claims where the main ground is an environmental damage. So let's, remember the very famous claim in the UK against BHP for damage caused by the collapse of Mariana and Brumadinho dams in Brazil. We have DS, so claims where the main ground is social, and we can include a lot of things in social, but I would say the most common claims in Europe, in the UK, Netherlands, Germany, and France is forced labor. That falls into the S of ESG. So claims for slavery, for work which is not slavery but forced work, works which are similar or tantamount to slavery, and we're gonna go through some cases in the next slide. Then there is G, so governance, and those are mainly cases brought by shareholders. There is one very famous case in the Netherlands, which is a class action, for example, against Petrobras by bondholders, by European bondholders, who are claiming losses caused by the car wash operation. So that's for the object. And finally, I think we can classify those claims in relation to who are the defendant. So there are a number of claims in the UK and in France, for example, where the claimants are suing the parent company for damages caused by the subsidiary. There are a couple of cases. There is one famous case in the UK where the claimants are suing the investor for damages caused by their investee in different parts of the world. There are cases where claimants are suing banks, funders, for damages caused by their funded parties, by their debtors in different parts of the world, which is very interesting, which means we are also, as a bank, we also need to conduct due diligence in relation to who we are funding. So that's a very, very interesting point. And finally, there is even claims against subsidiaries for damage caused by their holdings, which seems illogical, but then there is the idea that even if you are a subsidiary, you might be considered someone who has benefited for the damage of another company of your group. So I think now we're gonna go to the last slide, and then I've put here, so looking at that panorama of those three different forms of classifying those cases, I think we can go a little bit more into the detail into, very quickly, what are these cases? And I think what I try to do here, guys, is I try to separate those cases by what kind of due diligence failure was at the outset of those claims. And so the first one are cases where there is a failure of due diligence of the parent company in relation to the activities of the subsidiary. So in the UK, we have, for example, I think, two very important cases: the Vedanta case, where a British company was sued by damages caused by its subsidiary in Zambia. And we have the famous dam case, the Mariana case, where BHP in England is being sued for damage caused by BHP Brazil, and which in turn was the holding company for Samarco. So it's a two-level parent company claim. Of course, I'm simplifying things. The claim is much more complex than that, but the original idea behind those first types of claim is that you are saying that if you are the parent company, if you are the holding of a group of companies who has extractivist and risky activities in different parts of the world, you can't just say I didn't know how they were operating. And that comes into the idea, presented by Marianne and Camila, that you need to be sure that you can prove and you can make and you can bring evidence for a dispute or to prevent a dispute, that you have conducted diligence on the operations of the group of the companies belonging to a group, either subsidiaries or holdings, or even companies which are lateral, simply belonging to the same group of company. In France, we also have a couple of these cases. We have two. We have one case which involves Total Energy, which is being sued on a case related to Uganda. We have one case involving Suez for a claim by its subsidiary in Chile. There's a second set of types of claims in terms of due diligence, which are the claims where there is a failed due diligence of the investor when investing in a company abroad. That is still more interesting. In that case, what the main ground is to say, well, if you put in money, if you're investing your money somewhere, you need to be aware of what's going on in the company you're investing. So it means that, the free market, Adam Smith's invisible hand is not as invisible as it was. It means that you need some regulation. You need to know that the company where you put in your money needs to be complying with human rights rules and regulations. So it means for the investor that the investor also needs to prove and to raise evidence that it has conducted due diligence in the companies they are investing. So angel investor needs to be angels. They cannot just say, I'm just gonna drop my money in whatever activity because there is a very good opportunity, or because there is a financial reasoning that justifies investing that money. It doesn't work like that anymore. And according to those claims, you are liable if you invested in a company knowingly that company violated human rights locally. The third kind of due diligence failure is the one which is very present today in the UE regulations, which is the failure of due diligence of the buyer of a product or service for the activities of its suppliers abroad. I would say this is one of the most recent kinds of claims. So we have at least two very important claims. In the UK, we have one which is very famous, which is the Begum claim, where basically the family of an employee of a vessel recycling center in Bangladesh. So, a shipping disposal facility where they basically they destroy, old ships. So this guy in Bangladesh, this employee, he was killed in an accident during work, and his family sued the company who owned the ship in the UK, saying that when the company who sent the ship to be disposed in Bangladesh by this third-party contractor, they didn't do enough, they didn't conduct enough due diligence to verify that company in Bangladesh was in fact using slavery, was using forced labor. Okay, so you see how far that causal next goes into really, suing those guys for damages of, a supplier, in this case, the supplier of a service. There is a claim which was just started probably, a couple of months ago by Leaday, a leading class action firm in the UK against Dyson. Dyson, the guys who do the vacuums and the ventilators. This is a very interesting claim. Also, is a claim which was started in 2022, and again, it's the victims of a factory in Malaysia, which was a third party, which was, a supplier of Dyson in the UK. And these guys are suing Dyson in the UK for using, a factory, a plant, an industrial factory in Malaysia, which was also accused of using forced labor. And you can also, I just wanted to flag, you can also see how the UK is very focused, still in labor. Okay, that's why I think that the UK is lacking behind a little bit. It's very focused on labor and not so much in environmental and governance. In France, there's also a very interesting case where Casino, the retail company, is also being sued by the victims of one of its supplier in Latin America, which is also a subsidiary. It's a very interesting case because it's a little bit of both. It's a subsidiary, but also a supplier. And finally, that's what I would call the failure due diligence of an officer for the activities of its company. And here I would put the case of Client Earth versus Shell, where Client Earth, which is an NGO focused on climate change and environmental change and environmental protection, is suing Shell in the UK for and suing directors of Shell for not complying or not doing enough to implement the energy transition strategy of the company for net zero, or at least to replace fossil fuel. That's a very interesting case because a couple of weeks ago, the courts in the UK, they rejected that claim, saying that Client Earth could not sue in the quality of a derivative actions, because Client Earth is also a small shareholder of Shell. They bought some shares from Shell so that they could be suing the company as derivative actions, as replacing the shareholders and suing the directors for violations of the company. And in this case, the UK courts were in a very interesting decision, said, well, we are not in a place as courts of law to judge and to assess the complexities of how the directors of Shell are or are not implementing the energy transition strategy. And especially, that's an important point, they said, well, Client Earth in this case is only a shareholder because they want to bring this derivative claim. So that still will continue. In the UK, in the Netherlands, there's also the same case against Shell. I think the results over there are a little bit better, but here is still something which I think is very early days. So I think those are basically the cases. We can, of course, like as I said at the beginning, if you want to discuss any of these cases with a little bit more with a little bit more time, let me know. I'm more than happy to send you the decisions, or to go through any of these cases. So I think we're coming to the end of this presentation, and what I thought we would do at the end is kind of try to look at some trends, what we're expecting for the future, really. It's difficult because there's so many, this is a crystal ball exercise, because there's so many possibilities, there are so many ideas, there are so many, hypotheses that we are seeing. But I try to basically look at, I try to select 5, I would say, big movements that I can see today will probably or can be the future of ESG litigation and basically human rights due diligence in Europe. I think first is that we can see that the courts in Europe, they like those claims. I really think that looking at the decisions lately, there is a trend, there is a movement of courts and judges that are interested in hearing these claims. There is a very strong political and I would say popular movement in Europe, whereby people in Europe as a consumer market, they want their products to come through a clean value chain. They want companies in Europe selling iPhones or selling cars to prove that not only they comply with human rights due diligence, but that all the components of that car, all the components of that iPhone come from countries and for, third-party suppliers that also themselves go and comply. And just to refer to one very big, case in the UK, the Mariana BHP case. If you look at the decision, it really tells us, there is a willingness of judges to hear those cases, even if those cases are complex, even if those cases are very big, very voluminous. These cases are hundreds of thousands of claimants, and I think the message in the UK, for example, is it's not because it's too big, it's not because it's too complex that we will not hear it. So I think judges are, I would say today, more likely than not, to willing to hear those cases. The second is just it's just what Marianne and Camila told us. There is a real emergency of a human rights due diligence obligation. It's not about anymore just being passive in terms of, I think my subsidiary, I think my buyer, I think my seller in Brazil or in Zambia or in Vietnam is doing things right. No, we need to be proactive. We need to send people there to see if it's true. We need to conduct due diligence. So it's now a very active, a very proactive obligation that you need to understand that all the value chain, and that value chain is a very wide concept. All companies involved in aggregating value to your product or service can generate liability for you in Europe. And that's a very, very scary, but a very realistic, pragmatical thing we need to say here. Third, I think, which goes with the second, is just a normal consequence, increased importance of prevention and evidence gathering. It's not just about going down there, having Mariana, Camila, Wallbrook, and conducting the due diligence. And for me as a lawyer doing those disputes, I need evidence. I need you to record. I need you to tell me where can I see in your correspondence? Where can I see in how you are structured? Where can I see in your emails that you are worried about that supplier, that you think he might be a risk? I need to see evidence. You need to start building what I call a due diligence record. Okay, and that's gonna be essential if touch wood, but if once you have a claim, we need to see that you've dealt correctly, that you've taken the steps to look at it and not just let it go. Fourth, there is a rising number of contributory claims. What are those? Well, if those claims in Europe are being accepted by the judges, then the first thing a lot of the companies in Europe will do is to start claims against, the companies who directly caused the harm. So we will gonna have like a collective redress action against, a company in Europe, and then this company in Europe, as it doesn't want to, be held liable alone. So it will start also a claim against the company in Brazil who was, directly involved in causing the accident. So not only we need to be ready as companies in Europe to collective actions, but as companies in Europe, we also need to be ready to take action against sometimes our subsidiaries or against the companies we've invested or against, the buyers. So that's also a very important point. So that's also something when this comes to us and when we see there is a potential dispute, that's one question we need to answer is, well, what did you guys do to also, tell the guys who caused the damage in Brazil or in Mexico and Peru that, guys, you need now to cooperate because you also might need to be, dragged into the case in London, in the Netherlands, or in Paris, whatever. And finally, what I can see really is that there is very slowly, I feel there is a replacement of, governmental regulation by, class action regulation, by private enforcement. I think the governments are too slow. And I think, what we are seeing today and what we've heard from sources of the government in the UK is that, to be honest with you, and of course they will not say that, in public, but I think there is almost a feeling that, at the end of the day, all those class actions are also, helping improve, compliance with ESG standards. So, we will do our part. We will legislate. We will, issue regulations. The same for Europe. Those regulations, it takes time. We need votes. We need, debates. But at the end of the day, if there is a growing number of private individuals which are, getting together and that they are suing a lot of those companies for ESG damages, this is also something which can have a regulatory angle. So that's a little bit of my vision for the future. And, I think now we can I can see on my phone, there's a couple of questions already. And I will, let's see if I can take on. So there is one question from Jack White. So the question is, just on the Shell case, does the panel have any thoughts on the findings of the courts around good faith, namely that Client Earth was not acting in good faith because its investment in the company was tiny and he was using the case to highlight his concerns about Shells more broadly? This appears to be quite a significant bar on access to justice for civil society in cases of this kind. Well, that's exactly what I say, Jack. I think it's, well, I'm sorry, Camila and Mariana, I'm just I'm just answering because it seems like, addressed to the lawyer, the disputes lawyer. So yes, I agree with you, Jack. It's quite rigid. I confess to you, when I read, I understand the reasoning. I think the reasoning is technically correct. I think that was probably, the goal of Client Earth, though I don't have that information, I don't have any privileged information. But yes, it's gonna be a bar to access to justice, of course, because if you want to have a derivative action and you're not a shareholder, it's difficult. On the other hand, it's a way for those NGOs to be able to have any, legitimacy, to have any, procedural standing. So I agree with you, and I think really this is something that maybe can be reviewed by other courts. I see, if you compare the Client Earth case here in Amsterdam, in Rotterdam, you see different reasonings. So I think it's still a little bit of early days, to be honest. The reasoning is correct, but I agree with you that it might be a little bit strict and it might, prevent the access to justice of those NGOs wanting to, change or at least stimulate changes in how officers behave or how officers react to implementing long-term environmental plans. Let me see, there is, not sure I answer, sorry, Jack. The reflection that the space vacated by government enforcement is being filled by private civil society actions is interesting. Does this mean we are moving closer to a West model where litigation risk as opposed to regulatory risk is key for business? I think so, Jack. I think so. I don't think we're gonna move, at least not in the UK. I'm talking for the UK. I don't think the UK will move to a class action regime like the US. I think we're still gonna be like the GLO regime, where we're gonna have like multiple claimants which are managed together. I don't think the UK courts want to have a class action, a US class action style litigation, because it became such a big market and it became such a, it becomes, the class actions in some way became, a mean by itself. It didn't in the US. So it kind of become this very monstrous market of, funders, claimants, lawyers. And I think the UK is a bit concerned about that. And I think so. They want to have claimants. They want to have claimants that they think they are worth being decided by the UK courts. And I think, yes, I think there is implicit view of government that this might be how, you know, a lot of the regulations will be implemented through private enforcement. But that's also early days. And, you know, like I said, I think if you look at why the UK has not yet passed law that could, you know, broaden the scope of labor of the Slavery Act, if there are already so many, you know, claims relating to, you know, environmental and governance in the UK. So yeah. We have another question. That might be the case in the UK, but in the Netherlands, it's quite the opposite, and the interpretation of the duty of care is quite broad and allows multiple parties to file a claim. Okay, I think that's an interesting observation. There's another question with regards to damages. For jurisdictions where there are no punitive damages like France, what could be, in your view, the reparation for forced labor or slavery? Would it be unpaid salaries and indemnification on the employees? In relation to shareholders, I would assume classical losses would apply, yes. And what do you see on the ground? Well, let's start with the easy answer. For shareholders, that's, you know, that's exactly the answer. You know, it's a lot of loss of values. The difference of shares is all about the business decision of acquiring the shares of the company. You know, 15 years ago, when we thought the company was transparent, and then, you know, a big corruption scandal come in, and then we didn't know about it. So it's the difference between the amount there and the amount here. It's a super difficult quantification because there are different aspects in terms of, you know, the willingness to take some risk. Who are the shareholders? Is this like a guy who is used to take some risk? Is this like, you know, a pension fund who doesn't take any risk? So what we saw on the ground is a bit more difficult than that, but that's the difference. I don't know, in terms of forced labor, to be honest, and maybe no, I don't know, Mariana, Camila, if you've seen any decisions on that yet. We haven't seen any decisions, at least in the UK. A lot of those cases settled, you know. I think it's the goal to settle, right? So at the end of the day, we don't know what's the outcome. I think in countries like France, where there isn't like punitive damages, it would be some sort of you know, kind of reprehension, or at least damages relating to, you know, lost salaries, or leaving grants to the family of the deceased. But honestly, at least in the UK, we haven't seen any case go through publicly which would give us a hint. But I don't know, Camila, Mariana, if you have any ideas on that.
Yeah, I think that not a judicial case, but pre-judicial, I'd say. So in Brazil, in the case of the wineries that come up in the media
Yeah,
of this year. So the companies that were involved with the case, so for those who doesn't know, for those who don't know, there was some allegations that some wineries in Brazil were using forced labor and modern slavery in their supply chain. So it was one of the suppliers actually that was using the forced labor. And then the wineries alleged that they didn't know, they weren't aware of it. So what they did, so that the prosecutors started a investigation, and before the case was settled or anything, they already signed a agreement with the public prosecutors, and then for remediation, they paid the salaries, they paid compensation and indemnification, but they also agreed to find other jobs for these employees, and for those employees that wanted to go back to their cities, they also provided the transport. So I mean, of course, it's it's always going to be hard to remedy this kind of violation. But this is the case that I have in mind now that's really, really recent. And from these also, like, it's really interesting to see, because of course, like, none of the wineries had any human rights due diligence in place. And the human rights due diligence was also something that they committed to implement when they signed this agreement with the public prosecutors.
Thank you, Camila. I think we have another one for you, Camila Mariana, from Juliana Leal. Well, excellent presentation. Thank you. How do you see the main influence of human rights European legislation for the Brazilian PL 572? And what are the main fundamental impacts in multinational companies based in Brazil can expect to have in case of the PL, if the PL is approved?
Yeah, thank you. I can share a few thoughts. And hi, Juliana. Good to see you. I think, you know, the answer for your first question in terms of the influence of the EU legislation for the Brazilian, we do think and feel very confidently that there will be this kind of wave effect, you know, not only in Brazil, but across the world, with the EU leading. But we see more and more countries with, you know, project laws like Brazil. And we do think once, you know, Europe leads, others will be playing catch up. So we do think, you know, that increases the chances of similar law and the PL in Brazil being approved as well. In terms of the fundamental impact, in general, I think, you know, it's once it's mandatory, then, you know, so far you have the UN guiding principles as a voluntary, but you will only be having legal risks arising from it if you commit and then you don't fulfill your commitment. So if you're doing some kind of greenwashing from a human rights perspective, once it becomes law, then it becomes a matter of compliance. So the legal risks are much greater for companies. So I know at the beginning, Daniel made a joke, like, is it a fortunate or unfortunate thing? I think my experience, you know, my background coming from civil society and now as a consultant, what I see mainly is clients that are willing to spend or put more resources on due diligence are clients that have experienced some kind of disaster or negative impact, and they kind of learn the lesson and, you know, start to put resources. Very few clients, you know, already see the importance and already put the resources first and center. So me personally, I really like the idea of laws coming into place as a way of encouraging or giving companies that extra push to think more proactively.
Thank you very much, Maria. I have a lot of questions. I'm not sure I'm going to be able to answer all that. We have one question from Domingo Rivarola. Daniel, do you think that the debate will be direct to causal link instead of only focus on due diligence? That's a very good question, Domingo, because honestly, until today, if we look at the cases in, you know, most of Europe, they are very much grounded on causal link in the nexus of causation between either corporations, so the next, you know, the nexus between the holding and the subsidiary, or between the investor and the investee, or between the funder and the funded company, or, you know, the nexus that exists between you know, a lot of those companies in the same group. But with the new due diligence, the human rights due diligence regulations, like Mariana just said, you know, it's going to be law. So we don't need anymore to worry about any cause and effect. Is just basically prove, one, I bought a product from a supplier in Brazil, for example, that was using labor, forced labor. Two, I sold that product in Europe. Three, I, European company, didn't do any due diligence to hire that supplier in Brazil. So it's much easier. And that's why we think, and that's why I think there's going to be much more claims, because at the end of the day, the discussion we have today, which is kind of complex, the guys bringing those claims, they've done, in a certain way, a very good job in terms of, creating arguments. It's like, the influence of the holding, the controlling, the whole of the majority shareholder, the duty of care, the indirect polluter principle for Brazilian cases. So all those were brought into Europe and are being decided by European judges. And now, basically, what Europe is saying with the due diligence, with the corporate sustainability due diligence regulation is just, forget all about that. Now it's just the law. So you need to, if you don't prove, if you don't have evidence that you've conducted your due diligence, you're liable, and that's it. I think we have time for one last question, and we are like almost free. We have 4 minutes. So a question from João Gabriel Rodrigues. Despite the Brazilian Corporation Act, which is Law 6404, provided since it's an action that the controlling shareholder has liabilities before shareholders, employees, and communities, unique paragraph of Article 116, these claims are almost in existence. Do you understand that there is a risk of such claims being brought in Europe courts based on a Brazilian material law? Yes, because most of the cases in Europe are applying Brazilian law. So, but they haven't been brought, through the Corporation Act. They have been brought through the environmental law. So there is a chance, but I think it's going to be much easier to bring. If it's an environmental claim, yes. I haven't seen any claims based on shareholders, so any claims based on the Corporation Act yet. So yeah. Well, guys, I think we're almost at the end. I think from my part, I just really wanted to thank you so much for, joining us. I think, Mariana, Camila, and myself, we are available on our emails. If you have any questions, we can circulate the emails. And if you want some decisions. So I'll just let Mariana, Camila, if you want just to say a quick last word.
No, very mindful of time. I think just want to say thank you everyone for joining us. And there was a question about the slides, so we can circulate that with everyone who attended, and for those who also couldn't make it. And yes, we are available. Our email addresses are on the deck. Feel free to reach out, and also very happy to connect with those I don't know on LinkedIn and continue the conversation there.
Yeah, thank you, everyone. It was very, very nice discussion.
Thank you very much, everyone. I hope you enjoyed, and good afternoon, good day for you guys also in Latin America, and good afternoon for everyone around here, and hope to see you soon. Bye-bye.